The result eventually was civil war. Certain southern states that had a deep investment in slavery felt threatened, believed that the future political history of the country was going to be going against them because the population centers were in the North. As more states came into the Union, the balance between slave and free states was going to be disrupted. They thought the next effort would be eventually to put pressure on the South to abolish slavery. So we have the Civil War, and then, of course, in the aftermath of the Civil War, we have a Republican-dominated Congress that institutes Reconstruction. And it's at that point when we have the 13th, 14th, and 15th Amendments, and we have a new set of, using your language, a new set of constitutional liberties and rights. And then that sets the stage for a reorientation of American constitutional jurisprudence with a much greater emphasis on civil rights and liberty.
I was fascinated to read that in 1875, Congress actually passed a Civil Rights Act forbidding racial discrimination in public accommodations, but the Supreme Court struck it down on the basis the power had no power to regulate private discrimination. That was rather startlingly early. And then obviously we kind of went back and forth in terms of this issue. We later have Plessy versus Ferguson and famously the separate but equal ruling. Talk more about, if you would, Professor, about the role of the 14th Amendment in shaping the High Court's decision at this time.
Well, remember, the 14th Amendment is a product of a Congress that is deeply opposed to the South and anxious to impose a more egalitarian and libertarian regime in the South, is supportive of racial minorities to a limited extent. But then what happens is, after the period, about 10 years, just about the time of the passage of the Civil Rights Act, which is still very much influenced by the Reconstruction Congress, there's kind of an effort to get past the Civil War, to welcome southern states back into the Union, and the understanding is that the reintegration of the South is going to be done at the expense of liberties for African Americans. So the construction of the 14th Amendment not to apply, and the Civil Rights Act not to apply to private discrimination, is part of that sort of tacit understanding. And this goes on well into the 20th century. It goes on in the 1920s. We still have enforced segregation as the dominant policy on all branches of the government in the 1930s.
How did the so-called doctrine of incorporation and applying the Bill of Rights to the states affect justices and decisions on the court?
Well, it's a very important move, because the original text of the Constitution does not anticipate that the states are restricted by things such as due process rights. It is necessary to have the 14th Amendment with its own due process clause, with its equal protection clause. And then the next question for justices is, does this mean that due process, as enforced against the states, includes the original Bill of Rights guarantees? And eventually the court concludes that it includes some of them. Well, that's very important, because most of the restrictions of civil liberties take place at the state level rather than the federal level.
Looking at the, moving ahead in time to the New Deal period in Roosevelt's court, I found this kind of interesting. Who are the four horsemen and the three musketeers on the court? Obviously, at this time, you have much more, it seems, a structure of polarization, conservative versus so-called liberal, and swing votes that then prevails as the courts go forward, and seems to be the basic makeup of the courts. Would you say that during the Roosevelt period, this solidified a bit more? And so tell us about that, if you would.
No, the the designation of justices as liberals and conservatives comes very late, really, in the commentary on the court. Justices are not designated in that fashion until the 1930s.
Okay.
And the designations come in the popular media.
Right.
And they center around a controversy that emerges in the Hughes Court. How receptive are the justices going to be to New Deal legislation, which enhances the power of the federal government, and also to social welfare legislation at the state level? And so you get what is called, the terms the Four Horsemen and the Three Musketeers are journalistic terms to signify the attitude of some justices on the Hughes Court toward these issues. The Four Horsemen of the apocalypse, that is to say, that portrayed as reactionaries who are resisting constitutional change. Justices Sutherland, Vandeventer, McReynolds, and Butler. And then you have three justices that are portrayed as sympathetic to the New Deal and to constitutional change: Brandeis, Stone, and Cardozo. And then you have two other justices, Hughes and Roberts, who are given the label swing justices. Now, these labels are vast oversimplifications. They neither capture the individual justice's attitude, nor are they limited to a very small sample of cases. But they become kind of popular epithets. And from then on, the court justices are described and continue to be described. The Roberts Court justices are described as, quote, conservatives or liberals, even though those labels are vast oversimplifications.
So this was really, in some ways, as you said, in the 30s, with the Roosevelt's court period, the beginning of kind of hype and press labeling. So, but not at all according to the reality of how the justices made decisions.
It's a beginning of an image of justices as political figures. It's not that they were never thought of as partisan. They were. I mean, the commentary in the Marshall Court suggests that people think the court is partisan. But the idea that justices are sort of no different in a way from congressmen in their attitudes, and that you can take constitutional cases and describe them in political terms is a 20th century phenomenon.
When I was reading Jeffrey Rosen's book, it was a rather useful book on the Supreme Court, one of the things they mention in an overview is that in general terms, and obviously this is very general, from the Civil War to the New Deal era, we moved more, as we talked about before the program, from a concern with property rights, admiralty law, to civil rights. Do you think this is a fair characterization of the gradual shift of the court preoccupations and cases?
Yes. I think that what he's describing is a change from what I would call Republican to Democratic constitutional theory. In Republican constitutional theory, the judiciary is a guardian of individual rights against the state. And most of those rights are defined in terms of property rights. So the critical cases for that period are where states try to use the police power to restrict property rights. The move to democratic constitutionalism suggests that majoritarian rule is important, and the relationship between the United States as a democracy and freedom of expression, for example, is a critical way to define the United States from Hitler's Germany and fascist Italy and communist Russia. So free speech particularly becomes a central concern for the court in the 1930s and 40s. Property becomes less of a concern because that court is more supportive of legislation that restricts some property rights.
Well, it's interesting that you bring up free speech. There's a recent case which I believe the Supreme Court is going to take involving a Topeka, Kansas situation with the father of a Marine who was killed in Iraq. And he is in a pitched battle, really, with the church out there because they tend to picket during funerals. This has been much in the news lately. And his argument, of course, is privacy issues, and the church's issue is free speech. And I'd be interesting to see, I know this started in October, when the court takes it and how they decide.
Well, this actually, I don't think this case, although it's an unfortunate case, but I don't think this case is as difficult as it may be portrayed. It is clear that you can hold a rally and express your views on a public street. If that happens to be adjacent to where a funeral is taking place, that may be unfortunate, but you can do it. There is a doctrine in free speech jurisprudence called public forum doctrine. That means essentially that there are designated areas where citizens can express their views, and they tend to be public areas, streets and parks, for example. And although the government can sometimes regulate these areas, for example, they can ask for a permit to speak in a park, or they can say you can only speak in certain hours of the day. Other than that, there's not much control, and they particularly cannot regulate the content of what is being said. So if these protesters stood outside the area where there was a funeral taking place and chanted, even if the chantings were highly offensive to the family holding the funeral, or maybe even disruptive of the funeral, that speech is probably protected. Now, if it tends to aggravate a breach of the peace or something, that's another matter. But if you just basically express your views, even though they may not be attractive ones, in a public forum, then they're typically can't be regulated.
So likely then that the justices, if they take the case, would rule in favor of free speech and the church.
Yeah, unless there may be some facts in the case that suggest that the protesters actually invaded the private property on which the funeral was taking place. That would be a different matter.
But failing that,
even though these are offensive comments and clearly were directed at the family involved because it was the funeral of a person who had served in the military, so even though it's clear that they would cause some distress, absent the ability to show that this sort of intentional infliction of emotional distress, I think the speech is probably protected.
I want to thank you for agreeing to be with us again today. I want to thank you at home for joining in on our discussion. We have posted a number of books on our website which relates to present and past programs at Politics Matters, as well as interesting websites, columnists, and blogs on both sides of the aisle for you to look at. Our website address is politicsmatters.org. We'd like to hear from you with all questions and concerns for upcoming programs on Politics Matters. You can email us at info@politicsmatters.org. Thank you until next time, and thank you again, Professor White. I'm Jan Painter, and Politics Matters.